Thank you. And we know that there are a lot of questions about family and medical leave, the Paid Leave Act, how those acts intersect with one another, benefits, all of it. So you won't get any better person to answer your questions than Erin Choquette. Erin, as I mentioned, is General Counsel for the Paid Leave Authority. She also spent 14 years in the Department of Administrative Services, and she is considered one of the state's foremost experts in FMLA. So Erin, we're delighted to have you. I always feel very fortunate to work with you every day. So please take it away. Thank you for being here and doing a
great job. Thank you so much, Andreas. I'm just going to skip through about the presenter slide and jump right into the agenda. So just a couple of housekeeping matters. We are recording, so this recording will be available for you upon request. We can also share the slide deck with you. If you notify us, if you registered, we can share the slide deck with you. If you have questions during the presentation, please use the QA function in Zoom to submit those questions. Please do not put your questions in chat. If the questions are in the QA function, we have the ability to track them even after the recording, after the Zoom meeting is over, so we can make sure we get back to you. Please also don't raise your hand because this is presentation mode, so I won't be able to hear you if you ask to speak. So this morning, we're going to talk about the Connecticut Paid Leave Program, and then we're really going to focus on what is FMLA versus the Connecticut Paid Leave and how we're going to be implementing the Connecticut Paid Leave Act and implementing the changes of Connecticut FMLA. And then we'll share some resources with you so that you have them available to you and you know where to go if you need assistance. First, let's just talk a little bit about the Connecticut Paid Leave Authority. We're a quasi-public agency that was created by Public Act 1925 to actually stand up the Connecticut Paid Leave Program. Our goal is to make sure that Connecticut workers have the ability to access income replacement if they need to take time off from work to care for themselves or to care for a loved one. We also want to make sure that employers, administrators, and healthcare providers understand the Connecticut Paid Leave Act and understand their roles and have the tools they need to be able to fulfill their responsibilities. At the Connecticut Paid Leave Authority, we have several statutory responsibilities, including outreach and engagement. So we spent a lot of time working on making sure that we're getting the message out to workers, to employers about the Connecticut Paid Leave Program and what their rights and responsibilities are, which is one of the reasons we do these webinars. We also have to stand up the program. So we have to create the policies and procedures to run the program and make sure that people know what they need to do. Part of the program is, of course, collecting the employees' contributions so that we can fund the benefits. So we have that responsibility. We also have a responsibility for reviewing applications from employers who wish to fulfill their obligations under the Paid Leave Act through a private plan, rather than have their employees participate in the public program. So reviewing those applications and then auditing private plans is something we do as well. And then the big thing is administering those claims for paid leave benefits. Benefits will become available starting in January, and there's a lot to it. So we've been working very hard to make sure that we're up and running. We've contracted with a third-party administrator, FLAC, who will be helping us in this process, and we're going to be up and running. We've been working very hard. So just about a year ago, our website went live. Employer registration opened last November. So employers in Connecticut need to register with us so that they can create their accounts so that they can start remitting those deductions. The deductions or the contributions were supposed to start in January of 2021. And employers have to remit those contributions on a quarterly basis. So we're into our third quarter now. As I mentioned, we also have this private plan option. So if you're an employer who wishes to fulfill your obligations through a private plan, you can apply to us, and we've been reviewing applications for several months now. We've been receiving those contributions, and we've been working to go live in December to start receiving applications for benefits. We won't be able to issue benefits until January under the statute, but we're going to open up our claims processing in December so we can get a jump start. So a lot going on. Just as a threshold matter, let's talk about who's covered under the Connecticut Paid Leave Program. And the short answer is almost every employer that is located in Connecticut or has workers in Connecticut are covered. The statute says that if you have one or more people working in Connecticut, you are covered. That includes not-for-profits, that includes private sector employers with unionized workforces. Even if you don't pay into unemployment insurance, if you are still an employer who has employees working in Connecticut, you're covered. The statute also allows sole proprietors and self-employed individuals to opt in for themselves. So if you're a sole proprietor who has employees, you have to register for your employees. But if you wish to be covered as well, you could opt in. And if you're self-employed, you're an independent contractor, you could opt in if you like. If you do opt in those two situations, you must stay in the plan for at least 3 years. Under the statute, there are several entities that are excluded by statute. These are also the same entities, generally speaking, that are excluded from Connecticut FMLA. And that includes the federal government, the state of Connecticut, except as to covered public employees, and I'll define that in a minute. Municipalities and local or regional boards of education are also excluded unless they have covered public employees. And non-public elementary and secondary schools are excluded. So their employees do not contribute to the program and will not be able to receive benefits. There are other statutes that exclude their employees or employees from state programs. So it's not specifically listed in the Connecticut Paid Leave Act, but there are other statutes which apply, like railroad workers who have their own benefits, individuals who are employed by governments of other states, as well as employees of sovereign nations are not subject to Connecticut rules. One tricky little thing is that employees who are engaged in interstate commerce, so long distance truck drivers, maybe if they work in Connecticut but live in another state, they don't pay income tax in Connecticut, and so they're also not subject to this law. So it's this tweaky little thing. Similarly, if you are a spouse of an active duty military member who is currently living in Connecticut, but you've opted to pay your taxes in your home state instead of where you're currently deployed, you're considered a resident of that home state, and so not Connecticut and not working in Connecticut. I promised I would define covered public employees. So a covered public employee is someone who does participate in the Connecticut Paid Leave Program. They do remit their 0.5% contribution and will be allowed to apply for benefits. Covered public employees include non-unionized employees of the state of Connecticut. So managers, appointed officials, elected officials, we're all participating. Unionized employees of the state will only participate if they collectively bargain to be included. Now, with municipalities and local and regional boards of education, they're all excluded right now, but if they're unionized employees collectively bargain to be included, then everybody, union and non-union, comes in. As I mentioned, sole proprietors, independent contractors are not required to participate if they meet the definition of self-employment. So basically, if you pay self-employment taxes as defined by the IRS, then you are not an employee, you are self-employed, and you are not required to participate in the paid leave program. You can enroll if you want to. Your contributions will be based on 0.5% of your self-employment earnings. And as I mentioned, you'd stay enrolled for at least 3 years. If you're a sole prop who has employees, you do have to register at least for your employees, whether or not you enroll yourself. On the other hand, if you are a business owner, but you've structured your organization such that you are also an employee and you give yourself a W-2, you're considered to be an employee under federal and state law. And so you're also an employee for purposes of the Connecticut Paid Leave Program. So as I mentioned, the contributions are 0.5%. These are based on your employees' FICA wages. So, the way I think it's box 3 or 4 on the W-2, but it's the Social Security wages, and they're capped at the Social Security contribution limit. So the employee pays the money, but the employer is responsible for deducting the wages out of the paycheck and remitting those contributions on a quarterly basis to the authority. We receive those contributions and their money is deposited into the paid leave trust, which is actually administered by the Office of the State Treasurer. And that paid leave trust funds the benefits. All right, let's talk a little bit about FMLA and paid family medical leave, or Connecticut paid leave, depending on which acronym you're used to. FMLA, people throw those letters around all the time, and I'm not always sure that people know what they're saying when they reference FMLA. So FMLA technically stands for Family and Medical Leave Act. The reason I'm not always sure if people know specifically what they're saying when they say FMLA is because there are two FMLAs, at least for our purposes. There's a federal FMLA and there's also a Connecticut FMLA. Both of these laws allow eligible employees to take job protected time away from work for certain reasons. And both laws state that the leave is unpaid. They go on to say that employers may adopt policies to provide income replacement during leave, either through straight wage replacement or by allowing or requiring employees to use their paid time off, or PTO, while they're out on leave. So both of these laws have been in effect for over 20 years. They both took effect in the 90s. And they both allow for job protected time away from work, which is unpaid. As we'll talk about, the Connecticut FMLA will change significantly come January. Specifically, the eligibility requirements will change and the amount of time that you get will change. So right now, you're eligible for Connecticut FMLA if you work for an employer with 75 or more employees, and you've worked at least 12 months for that employer, and you worked at least 1,000 hours in the 12 months immediately before you take leave. And your entitlement is 16 weeks in a 24-month period. Starting in January, all of that changes. It's going to apply to employers with one or more employees working in Connecticut. So there are a lot of small businesses who've never done Connecticut FMLA who will start doing it. There will no longer be an hours worked requirement, and employees can receive the ability to take job protected leave after 3 months. The amount of leave also changes. Instead of the 16 weeks in a 24-month period, it will be 12 weeks in a 12-month period. There is a type of leave called military caregiver leave, which is when a family member has been injured in the line of duty on active duty. And your employee could take up to 26 weeks of leave for an injured service member to care for that injured service member. The other change is that starting in January, an individual who has a serious health condition causing incapacitation during pregnancy could actually take an additional 2 weeks. So they could have a total of 14 weeks in a 12-month period. In addition to changing the eligibility and leave amount, there's one other change I want to flag for you, and that's with regard to what employers can do for policies relating to paid time off. As I mentioned, both federal and Connecticut FMLA say the leave is unpaid, but the employer can adopt policies to require or permit employees to use their PTO. Starting in January, employers still have that ability to require or permit employees to use their accrued time off if that's what they want to do. But you can't require your employee to exhaust all of their PTO while they're out on leave. You have to let them hold on to at least 2 weeks of accrued PTO, basically letting them hold on to that so they can use it for another purpose. So that's FMLA. What is CTPL? What is Connecticut paid leave? Well, Connecticut paid leave could refer to the statute, the program, or the authority. But generally speaking, when we're talking about Connecticut paid leave, we're talking about a program that creates a source of income replacement benefits for employees. It does not provide job protected leave. So there's no separate entitlement to take time off from work. The purpose of the Paid Leave Act is to provide income replacement for people who are out of work. Now, I've mentioned a couple of times that you can take leave or you can get income replacement for certain reasons. So what are those reasons? Well, the first is if you are sick, if you have a serious health condition and you need to receive treatment or take time to recover from your serious health condition, you can do that under both these laws. A serious health condition does include pregnancy. It also includes serving as an organ or bone marrow donor, as well as other illnesses or injuries. You can also take leave to care for a family member who has a serious health condition, and we call this caregiver leave. Then sort of the happy reason is bonding. So you can bond with your newborn baby or to bond with a newly placed adopted or foster child. There's also the ability to use this bonding leave for pre-placement activities associated with adoption or foster care. I've already talked to you a little bit about military caregiver leave. That's the leave your employee takes to care for a family member who's been injured on active duty in the military. And then there's also something called qualifying exigency leave. So that's when your employee has a parent or spouse or child who has been deployed to overseas active duty. And that employee needs to take time away from work to address specific issues associated with that call. Maybe it's going to a sending off ceremony or a welcome home ceremony. Maybe it's going to a lawyer or a bank to make financial arrangements while your parent, spouse, or child is overseas. There are 8 specific reasons that are defined as qualifying exigencies. And then finally, there's something called the family violence leave. So in Connecticut, since about 2012, employers have been required to provide their employees with at least 12 calendar days of unpaid leave to go to court, to relocate, or to receive counseling or treatment if they are experiencing family violence. So under the Connecticut Paid Leave Act, an employee can apply to the authority for benefits to receive income replacement during those 12 days. Caregiver leave is something that is going to be different. So, I should say that all of those reasons I just described, let me go back for a second, except for family violence, are also the reasons that you can take federal FMLA. But the definition of family is not the same as federal FMLA. So to take caregiver leave under federal FMLA, you have to be taking it for your parent or your spouse or a child who is under the age of 18 or is 18 and older and has a disability that prevents them from engaging in 3 or more activities of daily living. Under Connecticut FMLA, starting in January, and under the Connecticut Paid Leave Act, an employee can take leave and receive income replacement benefits if they have to care for a parent or a spouse or a son or daughter of any age. They can also take leave and receive income replacement benefits if they have to take time off to care for a sibling, a grandparent, a grandchild, or an individual related to the employee by blood or affinity whose close association the employee shows to be the equivalent of one of those family relationships. So caregiver leave is broader in Connecticut, or will be in January. We do get a lot of questions about that last category, the person related by blood or affinity whose close association is the equivalent. So what does that mean? Well, this is a definition of family member that is new to Connecticut, but has actually been used in the federal government for several years in connection with sick leave and bereavement leave. Other states and municipalities have also used it. It's basically a recognition that families come in all shapes and sizes. And so you may have a significant personal bond to an individual, even if you're not biologically or legally related to them. So it's a very fact-specific situation, and you're entitled to ask your employee to explain how this person is related to them, even if it's not by blood or law. So perhaps it's their aunt or uncle who relies on the employee for unpaid care and who has really been such a close part of their family that it's really more equivalent to a parent or a grandparent or a sibling. I know in my family, my great aunt really took the place of my grandmother who died when I was a baby. But my great aunt came to every event, every holiday. We did her grocery shopping for her, ended up doing her laundry for her. She was the equivalent of a grandparent. In Connecticut, we don't recognize common law marriage. So if you're not married to a person, you know, to quote Beyonce, if you haven't put a ring on it, you're not a spouse. But with this relation by affinity, a person who's unmarried but a significant other with whom your employee maintains a familial spouse-like relationship, that would now be covered. Okay, just a quick summary of the eligibility requirements for federal law, Connecticut FMLA, and Connecticut paid leave. As we've talked about, federal and Connecticut FMLA are slightly different. Under federal FMLA, which is not changing, you have to be employed by the employer for at least 12 months and work for at least 1,250 hours in the 12 months immediately preceding leave. In January, under Connecticut FMLA, you just have to work for the employer for 3 months before you can take job protected leave. To get income replacement benefits, we really look at the money. We don't look at how long you're employed by the employer. So an employee has to earn at least $2,325 in their highest earning quarter when you look at the first 4 of the 5 most recently completed quarters. We will also be looking to see if they've earned that $2,325 from multiple employers. So you could have someone who's got multiple part-time jobs. We look at the aggregate to determine the $2,325. The person also has to show that they're currently working in Connecticut, or if they're unemployed, they have to show that they had been working in Connecticut at some point in the 12 weeks before applying to us for benefits. Or if they're an enrolled sole prop, they have to show that they are residing in Connecticut and had enrolled. So as you can see, a person might be eligible for Connecticut FMLA, but not eligible for federal FMLA, or a person could be eligible for benefits from the paid leave authority, but not eligible for job protected leave. If they're eligible, they could get 12 weeks in a 12-month period of job protected leave under both federal or Connecticut FMLA. But as we've talked about, Connecticut is a little bit broader because you've also got those 12 days in a calendar year for the family violence leave and the 2 additional weeks of leave for incapacitation during pregnancy. With the paid leave benefits, we provide 12 weeks of income replacement benefits in a 12-month period for all leave reasons. And that includes military caregiver leave. We don't provide income replacement for the full 26 weeks. Okay, let me just take a moment and look. There's one question in the Q&A. So a person is asking about the interaction of employer-provided benefits and CT paid leave benefits. So I'm going to answer that in a few moments. So please continue to be patient. Let's talk about implementing the Connecticut Paid Leave Act. Okay, everybody's got a role. For Connecticut paid leave, there's 2 parts. One is the contributions, and then the other is the claims. For contributions, the employee is responsible for contributing the 0.5% of their FICA wages up to the Social Security contribution limit. The employer is responsible for registering with CT paid leave and creating their account. And then, as I mentioned, they have to deduct the contributions and remit them to the paid leave. We ask for some backup information. It's very limited, but just so we can connect the dots to make sure the employers are remitting the full contributions. The authority receives and reconciles those contributions. If there are any over or underpayments, we handle that. And starting next year, we will be imposing penalties for non-compliance. The Connecticut DOL has a very limited role in the contributions, and basically pursuant to their general wage and hour authority, they're responsible for determining if employers can take what we call catch-up contributions. So if you hadn't been taking your contributions since January, you need to get caught up. And so Connecticut DOL has given all employers in Connecticut until the end of September to take additional amounts, up to an additional 1% to try and get caught up. On the claims side, there's a little bit more to do. The worker has to submit the application. So it's the worker's responsibility, not the employer, to submit the application. When they do that, they're going to create their own CTPL account. They have to provide us with documentation to support their need for benefits. And they have to give us information about when they're actually out of work and if they have other sources of income. And they also are required by law to notify the employer about their claim. The employer will be asked to complete and give us an employment verification form so we can verify the employee's wages, schedule, and the like. We may need to ask for follow-up information to validate absences and other sources of income. And then the employer also needs to let the workers know about their own PTO policies. Are you going to require them to use their accruals? Do you offer a short-term disability policy? And of course, you are obligated to not discriminate or retaliate against your employees who file claims. The Paid Leave Authority, with our third-party administrator, AFLAC, will be handling the claims. We determine eligibility, we review the documentation, and approve or deny the claim as appropriate. If it's approved, we will calculate and pay benefits and monitor those ongoing claims. If we deny it, we will allow people to request a reconsideration. We are on the lookout for fraud, and we do have the ability to impose penalties for non-compliance, misrepresentation, and the like. The Connecticut Department of Labor is responsible for hearing appeals filed by employees or related parties if we deny a claim or impose penalties. So, how do we do this? Well, first, the worker submits the claim. They can go to ctpleave.org and set up their account, or they can call AFLAC directly. They have to submit some documentation, including an application checklist and certification to support the reason for leave and how much time they need, and if they have other jobs or other income that we need to take into consideration. First thing we'll do with AFLAC is determine their eligibility by validating the earnings, validating that they work for a covered employer. And then if it is eligible, we'll review the documentation, including a medical certification or other documentation and the employment verification to approve or deny the claim. We do give everybody an opportunity to cure their mistakes. So if documentation is not submitted, we'll notify the employee to say, come on, we need this. And if it's denied, we do have that opportunity to request reconsideration. If it's approved, we calculate benefits using the statutory formula. We have access to DOL data as well as other sources of information, including the employment verification form, to determine their earnings and to determine if there's any offsets needed. And then we'll be issuing the benefits through an electronic transfer or through a stored value or a debit card. Our plan is to issue benefits each Tuesday in arrears so that we have time to make sure that we're validating those offsets and making sure there's nothing that needs to be addressed in terms of absence verification. So for example, benefits that would be accrued for that first week of January would be issued on January 18th. And then the worker is responsible for notifying us of any changes in their status. They go back to work earlier, if they need more time, and if they're taking intermittent leave, which is lots of individual absences for the same reason, they'll need to keep us apprised of those absences. As I mentioned, the benefits are based on the statute, and it's really determined based on how much the worker earns. If their base weekly earnings are less than or equal to the minimum wage multiplied by 40, their weekly benefit payment is 95%. So, you know, starting last month in August, the minimum wage went up to $13 an hour. So a person who's earning less than or equal to $520 a week would get the 95% less any offsets. If the worker earns more than 40 times the Connecticut minimum wage, the benefit is 95% of the 40 times Connecticut minimum wage plus 60% of the difference between how much the employee is working and that Connecticut minimum wage times 40. However, in all circumstances, the benefit is capped at 60 times the Connecticut minimum wage. So even if you earn $200,000 a year, your benefit is still capped at 60 times the Connecticut minimum wage. So just by way of example, if you're earning Connecticut minimum wage, you get 95% of 40 times 13, which is $494 in benefits. Person who earns a little bit more, so worker B in this example earns $13.50 an hour, they would actually get the $494, which is 95% of 40 times 13 plus 60% of the difference and between what they earn and that base number. So that worker is going to get $506 a week in benefits. Just going to take another second to look at the QA. Nothing that I can answer at this second. So I'll move on to talk about that first question we got, which was really, how do we deal with the intersection between employer-provided PTO and the benefits? So our statute specifically says that an employee can receive both Connecticut paid leave benefits and employer-provided benefits as long as the total amount does not exceed 100% of the employee's regular wages. And Connecticut FMLA says the employer can permit or require an employee to use PTO as long as they hold on to those 2 weeks. So what do we do here? Well, first thing is, if you offer a short-term disability policy, check your policy, talk to your broker, and make sure you understand what that policy language is. A lot of policies say that they are the payer of last resort after the employee uses any employer-provided benefits or state benefits. So you want to check that. If your worker does not receive any employer-provided PTO, including short-term disability benefits, then that worker would receive the full amount of Connecticut paid leave benefits for the full period of leave. So the first day they're out on leave, that's going to be the first day they start receiving income replacement benefits. On the other hand, if you have a worker who receives employer-provided PTO that is equal to their regular pay for the full amount of time the employee is out on leave, then they're never accessing their CTPL benefits. So say you've got an employee who's got, 10 weeks of sick time accrued and they only need 3 weeks, and you require them to use their PTO, they'll just use that PTO for those 3 weeks, and their entitlement under CTPL hasn't been touched. They could use that later if they ever get sick again, but it's not touched for now. I think more often we're going to have people in the middle. So say you've got an employee who needs 3 weeks of leave, but they only have 1 week of PTO that you can require them to use. Well, for that first week, they'll be out on leave, but they won't touch any CTPL benefits. Their CTPL benefits will start once they've finished that first week, and they'll start on week 2. On the other hand, maybe you have a policy that says you will provide 60% of your employees' pay while they're out. Okay, so that may be that they will receive 60% of their pay from you and the remainder from CTPL. And so they're going to be getting both employer-provided benefits and CTP leave benefits from the beginning of their leave. So how they intersect really depends on the policies that you have in place and whether you're going to require your employees to use their accrued PTO. We tell workers that if they're trying to figure out what they're going to get, they need to ask their employers, what are our policies? Like, am I required to use my sick time if I'm out on my own sick leave? Can I use my sick time if I'm taking caregiver leave? And what are those short-term disability policies? As an employer, if you're concerned about your employees stacking their leave entitlements, so layering one leave entitlement on over another, you may want to seriously consider having your employees be required to use at least their sick time so that they can't hold all of their sick time in reserve and as an additional job protection after they've exhausted their FMLA. All right, so we've talked a lot about implementing Connecticut paid leave and the benefits. Let's talk about the changes to Connecticut FMLA and what that means to you as an employer. Because as an employer, you're handling the leave requests. You're handling what happens when the employee is out of work. So under Connecticut FMLA, the worker is required to notify you, the employer, about their need to take leave. 30 days in advance if the need is foreseeable, or as soon as practicable if it's not foreseeable. If you require them to submit an application, then they have to submit the application. And they have to provide you with documentation to support the need for leave. And they need to comply with your attendance and call-in policies. So if you say that you have to call in every day, then they have to call in every day. Which brings us to the employer's responsibilities. First thing, establish a policy if you don't have one already, including rules about PTO usage. Both federal and Connecticut FMLA say that you need to post information about those laws. You can get that poster from Connecticut DOL. So if you haven't done so, you should get that posted. When the employee comes to you and says, I need to take leave, you have to process the leave request. So determine if they're eligible and approve or deny the leave based on the documentation, and monitor the leave usage to make sure that they're not taking more time than they're entitled to and that it's consistent with the medical documentation they've given you. And you're going to have to manage the employee return to work situation. And of course, refrain from discrimination and retaliation. The Connecticut Department of Labor is the state agency that's responsible for enforcing Connecticut FMLA. So they are promulgating regulations, and they're updating those regulations actually as we speak. They do provide guidance on the CTDOL website to explain how Connecticut FMLA differs from federal FMLA. And they investigate complaints regarding denial of FMLA or discrimination relating to FMLA. The Paid Leave Authority actually has no official responsibilities in connection with FMLA, but it's really hard to explain Connecticut paid leave without talking about FMLA. So we've been doing a lot of training like this one to help people understand both laws. So I shared with you what employees will do when they apply to us for income replacement. The next two slides explain the process for what employees have to do when they apply to their employer for job protected leave. It starts with the worker notifying the employer that they need time off from work. The worker doesn't have to say FMLA. They just have to give you enough information so that you can infer that it might be protected under FMLA, and therefore you can take the next steps to verify. As I mentioned, it needs to be done timely. As the employer, you have to determine if the worker is eligible for Connecticut FMLA, and that asterisk is really to remind me to say, or other laws like federal FMLA. And you notify the worker if they need to provide you with any additional documentations like a medical certificate. You have 5 business days to notify the worker if they're eligible. This is not leave approval. This is just, yep, based on our records, you've been working for us for at least 3 months. And you have to provide them with a notice of rights and responsibilities, which tells the worker what their rights are and what they need to do to access those rights. The employee has to give you the required documentation. So the med cert, the adoption papers, military records. You have to give them at least 15 calendar days to provide that documentation. And if they contact you and say, I'm having a lot of trouble getting the doctor to fill out the med cert, or the adoption agency is taking a long time, you should give them additional time. The federal regulations say you should give them up to 15 more days. Once you get that documentation in, you have to review it and determine if it substantiates the need for leave. And so you notify the worker if the leave is approved or denied under Connecticut FMLA and other statutes. You have 5 business days to make that determination. And when you determine if it's approved, you have to let them know, okay, you're approved. We're going to require you to use your accruals. We need you to report in. You might need a fitness for duty before you come back. All of that information you tell them. If your employee has notified you in advance for a foreseeable leave, most of the stuff will be done before they go out. So then you need the worker to tell you, hey, I'm actually taking leave. Or it could be an intermittent leave, which as I described before, is multiple absences for the same leave reason. And so a person with intermittent leave has to say, okay, I'm going out on my intermittent leave now. I'm going to be back tomorrow, but they have to distinguish that from just calling out sick. Under FMLA, it's job protected leave. What does that mean? It means the employee gets their job back. It's the same job with the same terms and conditions as they had before they took leave. Now, some employers, when the employee takes medical leave, wants the employee to be totally recovered or 100% fit for duty before they come back. That's actually not something you can do. The Connecticut FMLA, as well as the Americans with Disabilities Act, the ADA, and the Connecticut Fair Employment Practices Act, or CFEPA, says that you do have to consider providing reasonable accommodations to an employee with a disability. So they may not be 100% fit for duty, but they're able to come back to work and they just need minor modifications. You need to let them back in. So we're not going to lie to you. FMLA is not the easiest thing in the world to manage, right? It requires organization. It requires some forethought and communication with your employees and attention to detail. The very first thing you really need to do is make sure you have and enforce your attendance and call-in policies. And you want to make sure that when your workers call the supervisors let whoever's handling FMLA know. You don't want, weeks to go by and the supervisors say, oh yeah, Erin's been out for months. You want them to tell you right away. The second most important thing is dealing with incomplete or insufficient med certs. You are entitled to get a complete and sufficient med cert that gives you information that helps you determine if the person has a serious health condition and how much leave they need. And you want to ensure you get that. You don't get their entire medical file, but you should insist on a complete med cert. Intermittent leave is tricky. A lot of times employees who have conditions which require them to have intermittent leave or to take caregiver leave, it could be unforeseen absences, and that's job protected. And so you just kind of have to use that med cert to get a sense of how often they're likely to be out and make sure you're communicating with your employee. Some employers have workers who work fluctuating work weeks. So I work 40 hours this week, 32 hours next week, 52 hours a week after that. When you're talking about FMLA, you're talking about average work weeks. So there are specific rules for fluctuating work weeks that if that's your industry, you should pay attention to. And as I've mentioned, I keep focusing on Connecticut FMLA, but there's also federal FMLA and other laws like the ADA and CFEPA that you need to be aware of. Finally, you may have the circumstance where you have an employee who says, I don't want this to be called FMLA. I get that FMLA is job protected, but I've got all sorts of sick leave. I don't want to use up my 12 weeks right now. Well, your right, and frankly, your responsibility is to designate time off that qualifies as FMLA. That protects you as the employer because they can't come back and say you denied them FMLA or interfered with their rights to take FMLA. It also protects the worker because it does give them job protection. So even if they don't ask for it to be designated as FMLA, or they say, no, I want to hold off on it. If it qualifies as FMLA, you designate it and you start counting down those 12 weeks. Just really slide here just to remind you of the other laws that might provide for job protection. The ones I haven't mentioned yet are Pregnancy Disability Act. So leave might be a reasonable accommodation under that, and workers' comp, obviously. So giving you a lot of information, and I will answer questions in just a moment, but before I do that, I just want to focus on a couple of things for you to take away. Go to our website, ctpleave.org. We've got all sorts of information for employers, including a toolkit, posters, communications that you can share with your employees, fact sheets, things that will help you explain to your employees what's going on and help you understand what this is. We also have videos on our YouTube page, as well as FAQs on our website. If you still have questions and you can't find the answer, you can contact us through our Contact Us button on ctpleave.org and submit your question there, and our Contact Us team will get back to you within the next day or so. We may have to research the answer to your question, so we'll acknowledge it and let you know if we're researching. We do not have a staffed phone line. We may be able to return calls, but we don't accept calls in. So you really want to use the contact us button to be able to submit questions to us. All right, I'm going to stop sharing my screen and look and see what kinds of questions have been coming in. So, all right. What information will paid leave or AFLAC provide employers about the approval or denial of benefits and how much benefits will be paid? So when an employee submits the application to us, we'll be asking the employee for contact information for the employer. And we'll be asking the employee to give the employment verification form to the employer. So we can kind of get the right contact information. When we make a determination that the claim is approved, AFLAC will notify the employer, most likely through email, saying, John Doe has submitted this request. We have approved John Doe for block leave from January 15th we have approved John Doe for income replacement benefits for a period of time from January 15th through March 15th. And the benefit rate will be $13 an hour or whatever it is. So it'll be sent to you as an email, most likely, and it will be sent at the time that we approve the claim. The timing will depend upon how quickly we get the supporting information from the worker to enable us to approve or deny the claim. So another question is, do you have to fill out both CTPL forms and FMLA forms? So yes, because they're different purposes and they go to different sources. So if you are looking to take job protected leave, you would submit the FMLA paperwork to your employer. Now, the Federal Department of Labor has some sample forms that employers can adopt, and the Connecticut Department of Labor is in the process of creating forms for employers to adopt. So that's something to be on the lookout for. But your employee will fill out whatever form the employer creates to the employer. And then for CTPL, they will fill out the forms that we require. As I mentioned, employees can do all of this online, or they can do it by phone. They can also submit things through email or fax. We also accept, good old-fashioned postal, US mail, but that adds time to the process. So we encourage people to go online. Employees will be able to access their claims account for themselves. Because this is employee funded and it's really the employee's benefit, the employers will not have access to employees' claims accounts. So next question is, what type of information does the employee need to submit the claim? Do they need company name, ID, etc.? So the employee will complete their application form, which includes the reason they're asking for benefits, how long they're asking for benefits, identity verification, and they will be required to give an employment verification form to their employer. That employment verification form will be completed by the employer, and the employer will submit it to AFLAC. Again, email, postal mail, fax. And on that employment verification form, we do ask for the contact person, the name of the company, the address, so that we can stay in communication with the employer. So next question that comes in is, if we're requiring them to use PTO, does that refer only to currently accrued PTO and not what they could earn for the entire year? Interesting question. So that really goes to what your policy says. If you're an employer who advances PTO to an employee before they've earned it, then whatever your rule has to account for that. If you, as an employer, say, we won't advance you PTO, you only have what's available to you at the time you accrue it, then your policy will address that. Okay, if our short-term disability policy pays 60% of wages up to 600 and it is paid as a last resort, are we allowed to reduce the short-term disability policy by the paid benefit? Yes. Like, there's no law that prohibits you from saying we're going to give you less. If you are in an industry that involves unionization, you may have to look at your collective bargaining agreements before you can make unilateral changes. And you may wish to consider sort of the impact on your employees, even if you're not in a unionized environment. But as I said, the statutes do not require employers to provide paid leave, and they do not require employers to go first. You just have to, we ask you what your policy is and then react accordingly. Next question, how are the updated CTDOL regulations, when are the updated CTL regulations going to be issued? So we stay in close contact with Connecticut Department of Labor, so I know that they are in the process of posting those regulations, but I'm not privy to exactly when they will be publicly posted. I know they're working very hard to get those issued so that employers have that information. So kind of keep an eye out. They did just update their website just the other day with guidance on how to handle employees who have taken Connecticut FMLA in 2021 under the old rules, which was that 16 weeks in a 2-year period, and then what that means for someone who wants to take leave in 2022. So if you go to the Connecticut DOL website, you'll see that guidance has been posted, and I'm sure the regulations will be posted there as well. Question about how the average work week is calculated. So for purposes of CTPL benefits and trying to determine average work week so we can figure out how much of your work week you're taking out for purposes of income replacement, we look back at 12 weeks. Question is, people are asking questions and sliding through. Is the CTPL 12 weeks in a calendar year, or is it a rolling 12-month look back? We're actually using the 12-month look back process. So it's, you start leave and start receiving benefits on June 22nd of 2022. We're going to do a 12-month look back. So as opposed to doing it in a calendar year. Next question, do you have a direct phone number to AFLAC to start the process in December? There is a phone number, but we are not publicizing that yet because that phone number is not yet live. So we don't want people just calling a phone number that's never going to be answered. But as we get closer to December, we will be posting that phone number. Can both parents take leave to bond with a child? Yes. If we have fewer than 10 employees, we don't have to worry about FMLA, just paid leave, correct? No. Please remember, Connecticut FMLA applies to employers with 1 or more employees. And that's where employees go to get job protected leave. So if you have 1 or more employees, you will have employees who can apply to you as the employer for job protected leave. And then they can also apply to Connecticut paid leave for income replacement benefits. Okay. Questions about employment verification form. How do you get that to AFLAC? Absolutely. Email, fax, or US mail. We love electronic things. It goes faster. The employment verification form is actually going to be posted on our website before it gets, so that with the other forms, we're going to be getting all of those posted on our website so people can start being familiar with them. If an employee on leave continues to accrue time off while they're out, what does that mean for the employer? Can you require your employee to use that time? Yes, if you choose to, as long as you make sure that they hold on to 2 weeks. Or you could say time accrued can't be utilized until they come back. That's up to you. New question, if an employee is out on workers' comp, can they get benefits from CTPL in addition to workers' comp? No. Our statute says that employees who are receiving workers' comp or unemployment insurance benefits or other income replacement benefits like Social Security disability cannot receive any money from CTPL. So they're getting workers' comp, and cannot get any money from CTPL. So, couple questions. Yes, there's some questions about, are we going to be posting instructions about how to apply for CTPL? And yes, that's actually a lot of that information is on our website right now. We've expanded our website as of last Friday to have that claims information. So check out ctpleave.org for that information. If an employee has sick PTO available, can they use that for their leave instead of applying to CT paid leave? Yes, absolutely. What if they don't want to use their PTO and apply for CT paid leave, and instead, can they do that? Well, that's up to the employer's policy. If the employer says, if you have PTO and we require you to use it, then the employee has to use that PTO before applying to CT paid leave. That's why we ask for that information in the employment verification, so we know what the employer's policy is. Sorry, let me scroll down. If an employee is out on short-term disability or FMLA leave starting December 15th, 2021 through January 30th, 2022, could they start claiming CTPL benefits starting January 1st, 2022? Yes. So they can be eligible to receive benefits starting in January for the month of January. We will not give anybody benefits for time taken before January 1st, 2022. Another similar question is, what happens if someone has already taken 12 weeks of FMLA in the past 12 months? Are they eligible to apply at all for CT paid leave? Okay. If they've already exhausted their 12 weeks of federal FMLA, then they're out until that 12-month period begins again. If they've used some of their Connecticut FMLA, look to what the Department of Labor has posted about how you handle that in terms of the new entitlement, switching from a 24-month period to a 12-month period. Basically, they're saying, kind of to summarize, but please check out their website. But basically they say you can take into consideration and deduct any time the employee took in 2021 against time in 2022. So that's for the job protected side. But even if a person is not eligible for job protected leave, they might be able to apply for income replacement when they're out of work. So you have an employee who has no job protected leave. Maybe they've used up their entitlement or they just aren't eligible. So they can't work, but they have no job protection. So maybe they lose their job. They could still apply to CTPL for the income replacement while they're out. Right, we're just coming on 12 o'clock, trying to make sure we're getting the answer to this question. One question was about railroad workers. Are we the employer supposed to block the deduction? So yes, you should not have doing deductions if you have railroad workers, and to our knowledge, we had provided that information several months ago, so hopefully you've got that. One question was, is it possible to provide the employer policies as a whole so we don't have to provide for every request? Yes, you should. You should be giving your employees your policies or make them available to your policies in advance, just like you give any other employee policies to your employees, so that you have that available instead of waiting until someone comes to you. Right?
Erin,
We can provide copies of the slides and the recording.
Erin,
asking. Yes, Andrea.
there was one more question that I think I had answered it separately, and that was how it works when a person, well, whether or not a person can take CT paid leave for one reason and then take leave under federal FML for another reason. So Ken, I know you mentioned you talked about the stacking of the leave before and wondered if you wouldn't just mind addressing it again.
Sure. So taking leave under Connecticut FMLA for a reason and then a separate reason under federal FMLA.
Yes.
Yeah. So yes, that could happen. You could have an employee who needs to take time off from work to care for their sibling. That's permitted under Connecticut FMLA. So they would start utilizing their 12-week entitlement of Connecticut FMLA. But it's not permitted under federal FMLA. So they haven't touched their federal FMLA entitlement. So you really do need to track your employees' Connecticut FMLA usage separately from their federal FMLA. If they're eligible for both and the leave reason qualifies for both, they'll be pulling Connecticut FMLA and federal FMLA at the same time. So as I said, you want to be organized and you want to be detail focused and track their Connecticut FMLA usage and their federal FMLA usage. And you want to identify and track their PTO usage so that you can know if they're using it or not, and if they're complying with your policies. So it does require a lot of managing, right? Like there's no getting around it. You do want to pay attention to it and track it and document what you're doing so that you know what's happening and your employees know what they're utilizing.
Thank you.
So we're just after 12 o'clock. We want to be responsive and respectful of people's time. So we'll close now, but we can share the slide deck and the recording to you. If you registered, we have your information so we can get that out to everybody.
Thank you, Erin, very much. And I would just ask everyone to make sure that they look for other webinars that we'll be giving on similar topics. Thank you.
All right.